a work or invention that is the result of creativity, such as a manuscript or a design, to which one has rights. These are visions or creations of the mind transformed into something tangible. These creations may either be a copyright, trademark, or patent.
Your intellectual property may be a creative work which is protected by a copyright, scientific or engineering which is the subject of patent, or a word, phrase, symbol, design, or a combination of these things that identifies your goods or services, known as a trademark.
Is a protection and exclusive right to copy, distribute, adapt, display, and perform a creative work, usually for a limited time.
The creative work may be in a literary, artistic, educational, or musical form. It is intended to protect the original expression of an idea in the form of a creative work, but not the idea itself.
A trademark is a recognizable sign or design or expression that identifies products or services from a particular source and distinguishes them from others. The trademark owner can be an individual, business organization, or any legal entity. A trademark may be located on a package, a label, a voucher, or on the product itself. Trademarks used to identify services are sometimes called service marks.
A patent is an exclusive right awarded for an invention, a product, or a technique that gives a new technological solution to a problem or provides a new way of doing something in general. Technical information related to the patent must also be publicly disclosed. A patent may be an invention, utility model, and industrial design.
An invention is a unique or novel device, method, composition, or process. The invention process is a process within an overall engineering and product development process. It may be an improvement upon a machine or product or a new process for creating an object or a result. An invention that achieves a completely unique function or result may be a radical breakthrough. Such works are novel and not obvious to others skilled in the same field. An inventor may be taking a big step forward towards success or failure.
A utility model is a protection option which is designed to protect innovations that are not sufficiently inventive to meet the inventive threshold required for standard patents application. It may be any useful machine, implement, tools, product, composition, process, improvement, or part of the same that is of practical utility, novelty, and industrial applicability.
Industrial design is design applied to physical products that are to be manufactured by mass production. It is the creative act of determining and defining a product's form and features, which takes place in advance of the manufacture or production of the product. It consists purely of repeated, often automated replication, while craft-based design is a process or approach in which the form of the product is determined by the product's creator, largely concurrent with the act of its production.
In filing for your IP applications, you need to have your government-issued IDs ready for filing the applications. You may file directly to the Intellectual Property Office of the Philippines or IPOPHIL through their website. That's ipophl.gov.ph.
Or you may file via the different ITSO or satellite offices in the Philippines. Here in Iloilo, it is the TTI office, or through the ITSO, a university franchised by the government to assist in filing IP application of their university or external clients. So, what is an ITSO? Well, it is an innovation and technology support office that helps the government in producing or developing IP applications.
A network of 100 ITSOs composed of higher education and research development institutions.
Get to know more about the University of San Agustin, ITSO. Add us on our FB account at facebook.com/itso.sanag.
You may file your IT application through us by scanning this QR code.
Know your rights.
Know your IT.
Know USA ITSO.